Доброе утро, уважаемые коллеги.
Good morning, ladies and gentlemen. If some of you fail to find a vacant seat, the organizers are bringing in more chairs, and so everything will be taken care of. Because we are pressed for time and we are late already anyway, I suggest, like Mr. Gorbachev used to say, I suggest that we begin. He used to mix up the stresses before we get down to business. I would like to encourage you all to get ready for it. Let me introduce to you our guests, our panelists. Above all, let me introduce Mr. John Cole Decor, President of the International Notariat Union. And I think that it is appropriate to take advantage of this event to express our heartfelt gratitude to him for his presentation yesterday at the plenary session, and for agreeing to come here to attend this event, to block out some time in his extremely busy schedule and participate in our Congress to speak for the global notariat in general and the Russian notariat in particular. Thank you so much, sir. Thank you. We appreciate it very, very much. The moderator of this roundtable will be Marianne Frison-Roche, who is sitting to my right. She's a professor at the Institute of Political Studies and a Doctor of Law. Speaking about Ms. Frison-Roche, it is appropriate to say that for the French notariat, she is the same as Professor Gangala Natalia Raskazova for our notary system, and some other researchers who are defenders of the notary system, who are like-minded people, and thankfully they are with us at this roundtable today. Benoît Renaud, who is president of the highest notariat council in France. He did not make a formal presentation at the plenary session yesterday, but he exchanged a couple of comments with Mr. Medvedev and assured him that the role of the notary system here should be at least the same as in France, and that is something we're very grateful to him for. Serge Pastor, he's a notary officer of the city of Paris, and he's coordinator of Russian-French cooperation, representing the Supreme Union of Notariat. He published an exciting article in the Law magazine. He has taken an instrumental part in developing notary cooperation between Russia and France. We have Laurent Bissot, our longtime friend from Switzerland. Laurent Bissot is a notary officer from Lausanne, a member of the Commission for European Matters of the International Notariat Union. In the past, when we used to have a Swiss-Russian program, you remember he was a frequent visitor of Russia, and we used to be frequent visitors of Switzerland. At the development stage, they rendered instrumental help to us, and we're very thankful to them for that. We have Vice President of the Federal Notary Chamber of Germany, Mr. Koch. And Vitaly Schmidtkel from Germany. He's going to speak. And he is a notary officer from Germany. Let me put it out to you that this year we developed an agreement with the Federal Chamber of Germany, and there we included a lot of events to be held in Germany and in Russia. Following the example of our French colleagues, we have had the exchange system for 2 years already, having Russian notary officers going to Germany as an exchange fellows. We have Irina Likhalat, a notary officer from Kyiv, Ukraine. We have somebody from Kazakhstan, Asel Janapilova. She is from Kazakhstan, like I said. We have a notary officer from the Austrian Chamber, Michael Müller. We have people from the Ministry of Justice of China. I may have left somebody out, but in addition to foreign guests that we have, we also have people from registration bodies. We have Vladimir Demirov, who is head of the Justice Directorate, Moscow. Once again, if I left somebody out and missed somebody, I apologize for that. But as we work, we all, of course, will meet together better. And if I didn't name somebody, we'll meet you anyway. Like I said, the moderator today will be a professor. And let me give the floor to Marianne Brison-Roche. Please ask the presenter to use the mic. Thank you very much. Thank you, Ms. President. Of course, you all know that the moderator's role is an impressive one, even though it is limited to reminding people of the discussion ground rules. You said that I am a professor of law, and as professors, we always tend to remind students of something they should respect. The ground rules at this round table are going to be very simple. Each of the participants can't take more than 10 minutes to make comments. Before he or she start making comments, he or she should introduce themselves and speak about the issues his respective region or country is facing. Tell us about how the notary profession is doing in their respective regions or countries, linking it to the countries or market economic development. And I do encourage you not to step aside from those subjects. I'm going to act as a school teacher. I'll be keeping an eye on you, and I will be a tough timekeeper. After the 10-minute long presentation, every person will be entitled to ask a question, because the idea here is to have a discussion. It's a two-way street process, so I would like to encourage questions. We are not here to make defense attorney statements or the prosecutor's opening remarks, and we're not here to speak as professors. We're here to discuss and debate, and if it's okay with you and with Ms. President, Ms. Chairperson, I would like to make a brief introduction into the subject. Let me introduce myself, even though I have been introduced already. I'm a professor of law in Paris. I'm a unique professor of law because I specialize in notary issues. Economic law, in particular, I focus on the markets, and I have to admit that I'm familiar with economic theory and economic practice alike. it will be based on the economy, on the economic reality and economic theory existing in different countries that I examine different professional communities, different systems, different instruments like legal instruments, and I focus on how they may be used to promote economic development. That is what I specialize in. That is why I'm here. And Ms. Chairperson, I would like to thank you sincerely for asking me to moderate this roundtable. Well, I'm in charge of moderating this roundtable, so let me say something before I give you the floor. I wouldn't like to go back to what was discussed yesterday, but we are going through this time of market globalization. Market globalization means that the markets now recognize no borders as they develop, and the governments, therefore, the nations, they still retain a certain attitude to their borders because the government, the nation is defined by the borders, among other things. Therefore, the markets today are becoming much broader than the nation's borders. And even if they are financial markets, or if you have e-commerce, in those instances there's no borders at all. It doesn't mean that we go beyond the borders. It just means that there's no borders, and there's the difference between the two. So as you see, the government is not just in a situation where we go beyond the borders. Once again, the borders don't exist. Notary offices are an instrument of the government. What is their role in such a peculiar situation? And because the governments no longer exist within the framework of economic globalization, where the government as such stops existing, notary offices stop existing as well, don't they? And that is the first truth that we have to accept, the first statement we have to make. Because the notary officer is authorized by the government, how can a notary officer survive in a global economy? That is the question. When you look at the market, and if you look at the market, you can see that some of them are coming through a crisis. What lessons should we learn from the crisis of 2008? Above anything else, that was a crisis of trust. The trust is the fundamental issue, because it's about who I can trust, what I can trust. And actually that is a significant part of the economic theory, a significant part of the information theory, trust is. In that context, the notary officer receives very impressive authority from the government, which is the authority to make sure that something is not debatable or contented. So any document, even if it is erroneous or false, it can't be contented. Therefore, economic agents have such documents they know they may trust, because that is stated by the law. You deal with an indisputable document, and that has an impressive economic significance. More than ever, the markets these days need clear-cut regulation, and that is what notary offices can do. The less disputable an instrument is, a document is, because like I said, notary offices receive a lot of authority from the government, which is to notarize or confirm the documents.
And that's why it is even more important to have in this act the information, the most verified information. For that reason, the legal safety and security is so close to the issues of economic security, and it is under those conditions that people can function and the institutions can function properly. My observation of a person who is not a part of the notary community, to the extent and in the capacity as it was yesterday, the legal systems differ and they will keep being different from each other, and it is necessary for the notary community to be extremely disciplined and well organized, and moreover we need a kind of global international alliance, because the more the markets, the more structured professional communities are there on the market. I mean the professional communities that have regulatory liabilities, and they are they have the liabilities in terms of inaugural acts. The more they are governed by the standardized rules of behavior, the better will be the confidence in these professional communities from the market, and that's how the mutual confidence will be achieved. And while the trust and the confidence in the global economy is good for everyone, and this is a well-being, and trust is not built overnight and you cannot buy it on the market. Trust and confidence are either generated by the government or by the market itself. Besides, this is not a competing well-being, and because when a professional community generates trust, it does not compete in doing this with another professional community. Moreover, if a professional community generates trust and confidence, it is good for other professional communities as well. And the more trust and confidence is there on the market from different professional communities, whether these are judges, attorneys, lawyers, procurators, or notary officers, the higher the level in the legal, the level of the legal trust and confidence will be, because confidence is like information. This is a well-being for everyone, and this is what the markets are anticipating from us, and this is a very ambitious and very serious goal. A notary officer must act in accordance with the market interest. Markets require some global international things to happen, and the notary officers should keep it in mind. And they should keep in mind that they serve not the states, not only the states, but also the market. And I want to say that this is a well-being for everyone, and it is undisputable. For that particular reason, the notary community must be brought in line with the general standards. These will be my high-level remarks on the issues we're going to discuss at our round table. And I do hope that I brought you, I was exemplary in terms of sticking to timing, and we're looking forward to listen to you, Mr. President of the Federal Chamber of the Russian Federation. Well, I have my presentation here, my speaker's remarks here, but I would like to put them aside and just share my considerations with you. These are the considerations that, in my opinion, are extremely important for us today. Of course, myself, being the president of the Notary Chamber of Russia, I'm first of all taking care of the future of the Russian Notariat. However, to continue the considerations of Madam Professor, I want to say that we understand that we are an inseparable part of the global community, and in this or that way we are targeted at the global international development with the consideration of globalization, integration of law, of course, first of all on the European space, regulatory practice. And so in this sense, to say that Notariat today has no borderlines on the market and it should be the same in every country is not true. It is not the same even on the former USSR space. We have the representatives of Ukrainian Notariat here today, and their Notariat differs from ours, not in the positive way, unfortunately. Kazakhstan, Belarus, Moldova, so on and so forth. We would like, well, maybe this is not, I'm not modest in saying it, but I would like to talk about our draft law, which in my opinion could be a good example and a good benchmark for our neighbors in CSI on one hand, and on the other hand, we would like to, in terms of the content and the role of Notariat, and by the way, we need to increase the role of Notariat today in the society. We know that the civil code of the Russian Federation was adopted in the first reading in the parliament, and we saw there, envisaged there 10 to 12 additional actions for notary officers in what concerns the real estate deals, some corporate issues, and many other things. However, I would like to say that, of course, in the version of the first reading, the civil code will hardly turn into, the draft law will hardly turn into a law. I think there will be some changes made in the part of our relations with business. We recently had a conference. It was initiated by the Association of Entrepreneurs, and I was participating in that conference. The entrepreneurs there expressed their opinions, and they said that they don't want notary officers to verify the deals inside their business. They don't want notary officers to participate in their meetings, so on and so forth. And they were reasoning it by the fact that not all the notary officers are professional and keen on the dispossession deals in what concerns the capitals of the companies. And I want to say that we sometimes our interests mismatch, and the fact that businessmen sometimes consider notaries to be not so professional is caused by the fact that a notary officer refused to verify a document which didn't conform to the law. Sometimes documents are presented in the written form, and it is hard to understand from the document which share was exposed to which party, so on and so forth. And the notary officer understands that this document cannot be the core of the deal, and then a businessman just says the notary is a dumbhead, he is not professional, and he cannot cope with this task. When talking about it, I just replied and I said, yes, indeed, for 15 years we haven't been a part of a deal verification, and some of the experts lose their qualification in the course of time. But today we can confidently say that the notary officers of Russia are ready to cope with any challenge, because the majority of them have the working experience of 10 years and more. All of them have higher education in law, and all of them had vocational training. None of the industry today can boast about a well-enhanced vocational education system as Russia has. We have regular courses of vocational training, and every 5 years, according to the law, every 3 years, a notary should go to his vocational studies, which witnesses to the fact that we are really taking this issue seriously. I was recently at the parliamentary hearings in the State Duma 3 days ago, when they were discussing the civil codes draft law in the first reading. Then the Russian Chamber of Industrialists and Entrepreneurs and the Russian Union of Entrepreneurs were against the participation of notary officers in the deals. I was holding a speech there, and I said that we're not claiming at taking more responsibilities, because we assume that companies have a lot of lawyers in their headcount, and we hope that they can do this issue on their own. But to protect the rights of the citizens is the obligation of the government, and the government is doing this by hiring skillful notary officers to do this job. We were working on this issue with the committee of Pavel Krasheninnikov, and we thought it's really important to keep this stance. So if you are supporting this, we are going to defend that particular version of the draft law of the civil code. If you think we shouldn't do this, we will see what will happen in the future then. I am gonna be honest with you. I see the professionals here in this hall, and frankly speaking, we are not quite sure that if the article number 8 is the draft law of article number 8 is adopted as a law, we might not cope because of the qualification, quantities and quality, but we need to consider the realia. So I'm keen on knowing your point of view. Of course, we developed a strategy for the development of Notariat during the transitional period, where we put down all the liabilities and functions of the constituent entities of the Russian Federation, our professional union. So based on the decisions of the notary chambers, we developed the action plan. We will disseminate this action plan to you, and we would like you to read it carefully. I hope you don't mind if I take more time than it was planned. Thank you. On one hand, we have to have a clear-cut opinion on the measures related to the increase of the professionalism of notary officers. So in this sense, apart from the vocational training courses that we already have, we need to think of the prospective distance learning. We are planning now to build up a classifier for the main types of notary works. And Natalia Ivanovna, thank you so much for assisting in this work. We're going to classify all the areas notary officers are occupied in. and this classification will be available for all the notary offices. We will also conduct the systemic monitoring of the legislation, and probably we might have a temporary hotline, telephone line, to provide assistance to the notary offices. This might last for a year or so. And we may think of some short-term series of workshops on some topical issues. The St. Petersburg University, and Natalia Ivan told you already, the St. Petersburg University will try, on the basis of the civil code of the Russian Federation, to enhance and finalize the R&D work on the deals. And we will try to prepare a list of different agreements to help you at the initial stage. But you yourselves should also think of who could be of help, of practical and theoretical help for you, who is the one or who are the ones who can conduct workshops and seminars and to help you to overcome the challenges. We need to increase the role of the coordination methodological centers in the federal districts of the Russian Federation. A few more things. We need to realistically think of the volume of work every constituent entity of the Russian Federation, every notary officer might have. And we need to ask ourselves a question: are we happy with the headcount we have at the moment, or do we need to think of additional human resources? I'm more or less comfortable about this issue because I understand we have 3,500 representatives of Notariat. They have the licenses for notary work, and I believe that this is not going to be a grave problem. However, if the Ministry of Justice asks us about the headcount, we need to tell them in a straightforward manner that yes, we are okay, or in our opinion, we need to increase our headcount per this number of officers. We also have to realize that we are switching to a unified organizational form, and we will eliminate the state notariat at all. And in the nearest future you will receive a letter from us with a question: how many officers notary officers you may need in the remote regions of Russia, and how will it affect the financial situation of your notary chamber, so that you could understand, we could understand what would be the subsidies allocated by the federal notary chamber. Psychologically, we need to transform the minds of every notary officer. If people are not ready to be flexible and to transform their minds, they will not operate in this system. We need to work with information technologies in a comfortable manner. So we must be technically friendly, we must be technically equipped. In the first 6 months of the coming year, we need to finalize the issue of e-signatures to every notary officer. We need to begin our work with the Russian Registry Office, a federal tax service, so on and so forth. We need to enhance our work with them with digital signatures. Another thing to mention is we have to think, and we do insist, and the Ministry of Justice supports us in being so persistent. So we insist that in the transitional period we will have a series of exams for notary officers. I keep on saying that 99.9% of our notary officers shouldn't be afraid of these vocational exams, because the lion's share of our staff are highly professional and skillful officers. All that Madam Moderator mentioned conforms to the Russian Notariat. However, there are categories of of notary officers who must go away with re-evaluation of stuff. And very often mass media ask me, will it be a kind of exam for notary officers? No. I believe that during the years of work, every notary officer was at least tested 3 or 4 times thoroughly for the professionalism in notary work. Today, we have the certificate on the professional status of every notary officer, and we need to think how well equipped the notary officer's office is, how many ADs he has, how friendly this officer is with IT. So a whole set of requirements should describe this notary officer as a person who is likely to remain in our corps, and we trust this person, this professional. Another thing, we need to understand and have an appropriate approach to the responsibility and liabilities of the notary officer. We do understand the challenges set forth by the government. We are ready to have the expanded functions of notary officers in place. However, we want to release our notary officers from some liabilities, including the ones related to the property and real estate. We need to strengthen the role of insurance in our procedures.
If I had more time, I could go on and on and on and share some other significant ideas with you, but let me just put it out to you that the source of requirements to be met by the notary corps is time, and there's nothing we can do about that but meet the requirements. At this point, I would like to do something I'm unwilling to do in the presence of our guests, because I think extremely highly of our notary corps, but quite recently Galina Volkova, whom I'm sure you all know pretty well, attended a meeting of the notary chamber in the city of Orenburg. She came back to report about the meeting, and she said she was amazed to hear notary officers saying, "Leave us in peace, there's nothing else we want." That is the kind of mentality that is unacceptable, and those notary officers who are planning to keep thinking like that, and if we know about that thinking, and if we are part of the re-evaluation committee, we'll get our community, well, we'll get rid of them, we'll free our community of them. We can't accept this gap of mentality. We must be all united in how we perceive the profession, in our commitment, in our firm belief that we'll manage. Let me give you one more example of something that we should eradicate. Quite recently, we were asked to keep a record of automobile collaterals. We discussed that at our board meeting, and we said, no, we can't do that. We might accept the government's proposal and do that if those agreements might be notarized, and then there's no problem. We can notarize the agreement first, feed the agreement into the single information system, and keep record of them. Or another option under Act 405, the relationship between collateral giver and collateral taker, we could do the same and keep register. But we can't do something that we're not supposed to do. That is not part of the notary practice. And to turn notary officer into a record keeper, if people start doing that, if individuals start doing that there's no guarantees that all of the individuals end up with us. And if the banks start doing that, then we'll have to create an information system for 2,500 of banks. That will make us bankrupt. And well, then we were supported by the Ministry of Justice and by the government, but the Moscow City Chamber disagreed. But that is erroneous, isn't that? I'm almost done. So, like never before, we should be united in our spirit, in our efforts, in our discipline. I'm sorry, teacher, and thank you all for your patience. I'll never do it again, I promise. Спасибо огромное. Thank you very much. I knew at the outset that I will not be intimidating. Let me then embark on a different policy, the policy of begging. I beg with all of you to please respect the time limit, because that will give us some time for Q&As. You made a very exciting presentation. We heard about the importance of continuous education for the notary community. And no matter what privileges we receive from the government, no matter what breaks we receive from the government, it is our professional level that is number one in terms of its significance. And I really appreciated that you spoke about continuous education. You also said that the federative systems, like the system of your country, notary communities may be different in different regions. They can think differently, have different policies, and that means you should have a lot of discussions so that we all could better understand the links between the notary community and the legal system of a nation. Let me give the floor to our Swiss colleague now, because Switzerland, just like Russia, is a federation. They have several cantons, and the notary officers have direct authority vis-à-vis the economic law. Let me give you 10 minutes to make a presentation. I'll do my best to respect the time limit, Ms. Chairperson. Dear colleagues, and let me call you all dear friends, it is a great pleasure for me to find myself in this gorgeous city where every rock is full of history. Yesterday I was talking to my colleagues and sharing with them this perception of the city as a city of law. Empress Catherine the Great, if I remember correctly, was developing her decrees just like other Russian emperors, but let me be more prosaic and pragmatic today and cover the issue of notariat, the subject we are supposed to cover. First of all, I'm not a typical notary officer. More than 60% of what I do has to do with private international law, and more than 40 have to do with commercial law and trade law. In other words, I focus on quite a unique area, and I have nothing to do with ownership relations, and I'm a member of many organizations. My office, like Anne-Marie Frison-Roche argued, I'm working a great deal with Canadian and Belgian colleagues, and I have Italians and Irish people coming to my office as exchange fellows, just like Russians. Ms. Chairperson, you should have inferiority complexes in terms of the professional skills of Russian notary offices. The skills are extremely impressive, and I have always admired their professional and human skills alike. Anyway, the people who've been to my office have been wonderful. This lady, who's been our exchange student for the past several weeks, was able to deal with the most complicated lending documents. I'd like to say bravo to Russian notary offices. Before I get down to the essence of my presentation, let me put it out to you that on Tuesday I was working on some of the documents which had to do with litigation in Vietnam, France, and Germany. The cases required notary involvement, and as the professor said, the borders are going away, and we're working in the global space as opposed to individual nations. And now let me move over to the subject of my presentation per se. Notary officer is a necessary link connecting the legal stability to the financial stability. Quite recently, we have had this sense of frustration. We're going through a difficult time, and the world, I believe, has lost some benchmarks, and some have even lost hope for a better future. The reason, of course, is that what has been lost is the sense of stability. While stability is extremely important, it has been neglected. It has been put aside in a lot of cases. The stability is based on common sense, and you can't always find common sense in what people are doing these days. For a century, the Anglo-Saxon economic model was dominating. And at a certain time in history, it helped mankind to overcome feudalism. But now the model, I believe, should change dramatically. The stability, therefore, which may be legal and economic, is closely related to a whole range of factors. It's a factor of economic development and the idea of the government development for everyone's benefit. The concept of stability translates in the respect of the rule of law. Tallis used to say that it is very important to have harmonized body of legislation. It is this kind of legislation which ensures economic and political stability, while the concept of stability is linked to the concept of sustainability, the two concepts that promote democracy and democratic institutes. It is much more difficult to define economic stability. Let me quote some of Anglo-Saxon authors, in particular Jill Hammond, who used to speak a lot about the stability versus lack of stability. Chairman Decor said the plenary spoke at the plenary session about the important role of the government in promoting the stability of a country's development. I think that it is in this context that the lawyers should join their efforts for the sake of people's security and property security. How can you measure the stability? You may justifiably ask. A lot of theoretical articles, very sophisticated articles have been written, but let me simplify it for you. Ms. Professor, I would like to go back to this trust issue that you raised, and let me quote Pascal Couchepin, the president of the Swiss Confederation. It is 10 years ago that he defined trust in this way. He said that trust has three aspects. First of all, it means people's trust in their government as the highest authority. A second aspect is the trust in the economy, in the ground rules defined by the government. And the third aspect, finally, stands for the government's trust in the institutions responsible for different sectors of societal development. He also added that a notary officer is a very important link connecting the government and the population in the economic world. This trust should be guaranteed by four elements. Element number one is rule of law, because the law defines legal boundaries, if you will, legal borders for what the notary officer may and may not do. A notarized document is a legal document. The notary officer is different than other lawyers and attorneys because his authority comes from the government. He's a public official, he's a judge, a referee without litigation, if you will. While attorneys, well, they all are lawyers, of course, but the attorneys do not act as judges or referees, far from that. In that sense, a notary officer is very different than other lawyers, like I said, because the notary officer gets his authority from the government. There's another area of differentiation. The notary officer acts on behalf of the government, unlike many attorneys. It is important for the notary officer to be independent and to act independently. The only thing the notary officer can be guided by is the law. As he or she works, the notary officer is impartial and neutral. Thus, the notary officer represents all of the parties, and that makes him or her so different from an attorney who can only represent one party in court. And finally, the notary officer is neutral and impartial, and that makes it possible for him to carry out his functions in a neutral way. The evidentiary force is a characteristic of a notarized document, which is an uncontestable document. Every party interested in having a notarized document trusts the document, even though the notary officer is a liberal profession. Still, the officer is a public official. Thirdly, the third thing has to do with professional skills of a notary officer. The notary officer is an expert in law. Of course, notary officers should have university degrees, and they should be committed to continuing their education on an ongoing basis. That is quite necessary because the world we live in is very sophisticated, and you have to seek a compromise between liberalism and regulation at all times. The more we develop regulation of certain areas, the more difficult it is, the more complicated and sophisticated legislation is developed. So you may also say that it is the notary officer's duty to educate the client and consult the client, explaining to the client all of the nuances that have been developed in a certain area. The notary officer should be a reader of different characters, a reader of human soul, and respects the professional secret above all things. The notary officer should be in command of all of the information enabling him to be an expert in a given situation. The professional secret is a kind of protection of the client's private property, and the notary officer is the only person entitled to disclose that information. Integrity and the professional skills promote people's trust in the notary officer. The status of a person authorized by the government allows the notary officer to strengthen the government and be a guarantor of the authority. I've spoken very little about the economic players, but let me emphasize to you that any economy needs clearly defined rules. The notary officer is the bearer of those rules in his role of an intermediary between the government and the people. The notary officer can preempt what happens and even predict some economic or societal processes. Let me express my hope that the trust in the notary community is going to develop in our respective societies. The notary officers are lawyers outside the litigation field, and together they work for the shared goal, the single goal. They aspire to become an instrument which is the decisive factor of the economic and political stability. Thank you.
Thank you so much for this very informative presentation. And in spite of the fact that you didn't talk about the economic factors, you really told us in a very good, explicit manner about all the qualities a notary officer should possess in order to satisfy the professional standards. Thank you once again. Thank you very much. And your speech was coherent with Madam the Chairwoman's speech, and in the Russian Federation also we see that the government wants to strengthen Notariat. Let me switch to the next presentation. Please speak not more than 10 minutes. Let's talk about the shift to active Notariat. I don't mean that we were not talking about active Notariat, but we will talk about some element of activity now. Thank you so much, Mr. Chairman. Well, to continue our topic today, I would like to say that the economic efficiency of Notariat in our country is manifested just like it does in all other countries. We can highlight three big areas. Number one is the economic efficiency of Notariat in terms of the decrease of load on the legal and judicial system. It means that we facilitate the civil turnout. The second one is the role of a notary officer for the participants of the process in terms of saving their costs. And the third important aspect is related to the creation of the climate of confidence and the opportunity of using Notariat in both nationally and internationally. So let me switch from theory to some purely practical issues, because in the Center of Notarial Studies we conducted a few special researches, and and we wanted to check thus how Notariat contributes to the economic efficiency in our country and how can it decrease the load on the judicial system. We conducted this major research in 2006, and we were considering the official statistics of courts issued by the judicial department, and then we compared it with our statistics. We took as a ground the litigations related to probate proceedings, and we compared it with the number of probate issues led by the notary officers. In the regions, the average toleration was 0.5.4, and it differed from region to region. It means only 1 out of 200 probate proceedings go to courts. A number of regions showed us the figure 5, 6, 7% of probate proceedings. In Kalmykia, in Bashkortostan, we asked ourselves a question: why? The reason was that in those regions we had state notariat, and it was the business of state notary officers. The statistics shows us that a notary officer of a Latin type operating on a new system, he has a different attitude to his work, and that's why we saw this tenfold gap in the probate proceedings and cases. On Tuesday, I participated in the opening of the Russian Federation Supreme Plenum, and we were talking, amongst others, the practice of probate proceedings, and many speakers highlighted the important role of notariat. They said that the notary monopoly and the function on the proceedings on heritages contribute to the offloading the courts, and it is very good. And as for other doubtful issues, you know that the notary actions can be argued upon under the Article 38 of the Code of Procedure of Russian Federation. The statistics shows that to be realistic, per 1 million cases, notary cases, only 2,200 claims are submitted to the courts for notary actions out of million notary actions committed last year. Even if we take away 2/3 or 4/5 of simple actions of verification, copies, and verifying documents, 2,200 complaints going to the court, out of them 41.6% were satisfied by the court, show that notariat gives an undoubtful facilitation of the civil turnaround. We use these figures actively in the arguments with our colleagues when they ask ourselves what is the use of notariat. It is obvious. In terms of saving the costs of the participants of the civil proceedings, the figures are obvious as well. They show that if, in average, and there is a trick here, when they say that notariat is a certain administrative barrier and it makes you pay substantial amounts, this is not true, and it is shown in our research. It shows that the average rate of real estate agent who supports the deal amounts to 3 to 10% from the sum of the deal, while the notary fee amounts to 1% maximum from the deal, which shows that if we switch to the verification of real estate deals through notary offices only, this will bring to the huge saving of costs of the participants of civil proceedings. The statistics is obvious here. As for the active model, mentioned by the esteemed Madam the Chairwoman of our session, I would say that the draft law envisages a more active model of notariat, which allows a notary officer to support and accompany the entire process of the deal. This is the model of 1993 we are working on at the moment, and it's clear that the developers of the basis of notariat in Russia at that time, and many thanks to them, they managed to develop a wonderful law, but they couldn't provide everything in that law. The model of the basis of the notary law presumes the notary's participation at the stage of the deal. However, today the legislation on the registration of property rights allocates an additional function to the notary officer during the submission to the registration chamber. As for our project, it's a contemporary, a modern model of a notary officer who monitors the deal throughout through the whole period. When the notary officer collects the documents, verifies them, and then actually signs the deal and enacts the deal, because the notary officer is going to submit the documents to the registry for the registration, and then he is taking them back. In other words, this is a one-window principle we are going to exercise in this project. We are very grateful to our French colleagues because we studied the French practice thoroughly, but to avoid the situation Griboyedov described, a mix of Nizhny Novgorod dialect with French language, we adapted the French practice to the Russian realia, but in terms of the concept was taken from the French model of active notariat, which is very contributive for all the stakeholders, participants of the notary deal. Among other issues, we consider that in our project is the aspect of the convenient use and the executive power. A notary act, roughly speaking, any notary act has a term of execution, and you can skip going to court. You can go to the custodial officer for the enforcement of this decree, and the enforcement is nearly equal in its power to the law, and it allows to use actively the Notary Act in the civil proceedings internally. It has the same significance in the international context. Our agreements with Poland and Italy presume that the Notary Act has an undoubtful power, and it should be it can be equally enforced abroad. I believe that all these measures show the high economic efficiency of notariat for the Russian society. Thank you for your attention. Thank you so much for this interesting presentation. So through these concepts and understandings of active notariat, you showed us very well, very explicitly, that the comparative law is a realia, is a practice, and you can take the best practice from, for example, the French law, and if in the French law we have some issues that serve to the interests of the French society, these are some positive elements that can be replicated to the Russian society as well. plays an important role for the efficiency of the economy, and it has a central importance for the economy in general. And the law is high quality law only when it's efficient. That's very important, and that's the most important criterion. A high quality law is a good law. You said is an efficient law. You said that the notary work is efficient because it allows to solve the challenges in a more efficient way. The issue of efficiency is something to be continued in the speech of President Renaud, President of the Supreme Council of Notariat in France. Please. Thank you so much, Madam Chairwoman. I do hope I will stick to my timing. I am the president of the Supreme Notariat Council of France. It's active notariat, as it was mentioned by my colleague, and I'm grateful for this compliment. I want to say that we are always ready to assist to the modernization of our neighboring notariat communities, our friendly notariat communities. Dear friends, dear colleagues, on behalf of the notary officers of France, I would like to welcome you warmly, and taking into account that Ms. Sazonova is here, I would like to mention something I mentioned to Prime Minister Medvedev yesterday. We said that French notariat is always on your side and by your side, and we are ready to help you, as we used to do in the previous years, to promote the notary issues in the civil code, which is debated now at the moment in Duma. As for the economic efficiency of notariat, I'm going to cover two aspects of it, on microeconomic and macroeconomic levels. Civil notariat are present in 87 countries of the world. 2/3 of world population are covered by that. Such large countries as China and Russia are also included there. Notariat is an opportunity of the access to the law for the citizens. The economic efficiency we talked about is the result of the fact that the work of the notary officers is subject to the acceptable tariffs for the citizens, and due to the fact that notary officers are trying to exclude any fraud actions in their work, and they provide the verified data to the state archives and registration chambers. Notary officers are a very important factor to regulate market economy, and they promote and generate confidence on the market, in the market economy. Due to the dual status of a free professional and a person entitled by the government to exercise this function, a notary officer fulfills a number of functions. First of all, it's legal consultancies and counseling, like other lawyers do, but legal support is something a notary officer is providing to his clients. Of course, a notary officer collects all the documents, he verifies these documents, he verifies the deals, and besides, in France, notary officers get taxes as well, they collect taxes. In fact, notary officers are functioning, are playing an important role for tax collection in France, and since they have a wide circle of liabilities and responsibilities, a client who is not happy with the services provided by the notary can file a claim on the compensation of damage caused by the notary officer. And in fact, a notary officer is in every district, every region of the country. It is the government government. It is the state that decides where the notary officers are needed to provide the relevant services to the population. Notary officer is a symbol of what we call today the private-public partnership. And notary officers do perform a number of important functions. They do not only get the payments, remunerations from their clients. It is the government that decides the sizes of the remunerations for notary officers to guarantee all the members of the community the equal access to notary services. In France, although it's not the same in other countries, in France, a notary officer, apart from all other things, is collecting taxes for the government. It is the notary officer who calculates and identifies the size of the taxes and then collects these taxes, and these taxes must be paid in accordance with the acts the notary officer verified. For French government, it's a very important role of a notary officer, because we collect approximately 22 billion euros of taxes a year, and this tax collection is done without any other additional expenditures of the state, and it's an important constituent part of notary officers' job. And notary officers are personally responsible for the tax collection and submission of taxes to the government, and this process should be done in a diligent manner. A notary officer submits to all the collected amounts to the funds, which something we call the cash of deposits in the governmental institutions. And in this way, the government collects the long-term resources for investment to ensure public interest and the economic development of the country and the society. As my Swiss colleague already mentioned, the notary officers should give legal consultancies to their clients in a non-ambiguous manner, also through their acts.
And this consulting is offered to any client in a totally impartial way. It is the notary's duty to make sure that the parties understand the commitments they undertake, that they're quite voluntary in expressing their will. He must establish and verify who they are, their identity, and the French notary officer is expected to get in touch with different registers like cadastre or mortgage register or contractual register. As a person authorized by the government, it is the notary officer's responsibility to make sure that everything is transparent. Under the European directives, there is a requirement whereby if the notary officer has some doubts about the honesty of the underlying deed or transaction, he or she can report it, and that is a vital instrument in combating money laundering. That is a wonderful government and governing tool. The notary provides legal security, which is an integral right of individuals, investors, and companies alike. The legal security or safety is public treasury, and the notary officer is a lawyer who regulates that area. That was put down by Professor Chiller at the Yale University. He's one of the few scientists who knew there would be a mortgage loan crisis, and a while ago he said that to avoid such crisis in the United States, any mortgage borrower should talk to the lawyer appointed by the government. whose responsibility it will be to provide independent opinion to all the parties, establishing the identity of everyone involved in the deed. And of course, that means a notary officer. We are well aware that the mortgage crisis was caused by the fact that many ownership certificates were fraudulent. They were signed by the borrowers who did not have a clear idea of what documents they were signing in the first place. And that means that people have to resort to insurance, which is very expensive. So the risks are such that the system can fall apart, and that was demonstrated by the most recent mortgage crisis. That is security a posteriori, and the continental law can prevent difficulties and issues by a mechanism which creates written evidence, and that is done by the notary officers, who of course improve the efficiency of the whole system. Thanks to the continental system, it's not just the security that is protected, it's the distribution of risks that is ensured. In France, what happened in the United States is impossible. You remember the United States, one journalist bought Empire State Building in just 10 seconds. So he bought property and assets from somebody whom had been deceased for 10 years. Such deals result in daily losses of $800 billion in the United States, and that is quite impossible in France, because the notaries are a shield preventing such thing from occurring. All the documents certified by the notaries have full legal force, which means, and they are enforceable directly through court bailiffs. That helps avoid expensive litigation and unnecessary use of litigation and courts in several relationships. As for the real estate transactions and deals, it is only a notary officer who can certify the deals. It is them who are authorized to enter this information into the real estate register. As a result, the government has reliable statistical data which improves the security of all stakeholders. In conclusion, I would like to put it out to you that the notary offices help their clients to be economically efficient, because the notary officer is a single window of reliability and responsibility, because if he makes a mistake, it may be contested in court. If you remember that the notary officer is working for the government and does not cost a penny to the government, that improves, like I said, economic efficiency for the corporations and individuals. Because notary documents are indisputable, enforceable, so that helps me to conclude that the Notariat has a wonderful future, and I'm very proud that I belong to this wonderful community of notary offices. I'm sure that France, Russia, and other countries will continue to develop their Notariat. Thank you very much. Thank you so much. so much. You focused a lot on the connection between the notary officer and economic development. And to make sure that we have a positive economic development, we need some institutes. And the institutes should be powerful. That has a lot of significance in Russia, and why don't we listen to our colleague from Kazakhstan now, who is going to speak about the role of Notariat in Kazakhstan and how notary offices contribute to the economic development of her country. Dear colleagues, ladies and gentlemen, let me welcome all of you on behalf of the notary community of Kazakhstan and hope that the discussion of the issues we all are facing today will help the notary community of our countries to develop a single stance, even though we all work under different laws. How Notariat is linked to the economic development of society. I'm going to speak about them from the point of view of the Kazakh Notariat. Last year and at the beginning of this year, we had some dramatic changes in the legislation which governs notary activities in my country. The Notariat, as is well known, has a positive impact on the economic development of every nation, and that is caused by quite a unique function we carry out in our countries, in our administrative system and civil system, and as such we are quite instrumental for the economic and social development. Let me speak about the Notariat of my country. Like I said, we had dramatic changes last year and at the beginning of this year. The reason is that we no longer have any limits for the number of notary offices in my country. Of course, that has a significant impact on the economic situation of notary offices. Kazakhstan today, as of before the change was introduced, we had 2,000 notary offices in the country of 15 million. Now, after the 16th of January, and that was when the amendments were introduced, we have 500 notary offices more. In most instances, just like in Moscow and St. Petersburg, we have Astana and Almaty, two capitals, the former and the current capital. Let me give you an example. In Almaty, the population, total size of the city is 1.7 million. We used to have 370 notary offices. Now we have 150 more. In Astana is 1 million. We used to have 200 notary offices. Now we have 300. In other regions, the process is underway, but the process is not too dramatic. It is quite calm, probably because people are well set in their ways and they don't want to change their ways of life there. So those are the changes we have to accommodate ourselves. As for the economic situation of the Notariat, this is what I'd like to speak about. Mr. Yurkov mentioned three aspects. Number one, a decrease in the number of court cases. The role of Notariat in the civil turnover and improving trust in the notary community. We find all the three factors in our system. Civil deeds do not have to be notarized, but still they are notarized, practically all of them. What does it tell you? It tells you that people trust notary offices real much. Besides, Our notary offices are quite active. Why active? We've been around for 2 years. We have this electronic notariat program, and notary offices have access to every and any government databases. People involved in civil relationships can come to notary office and inquire any kind of information like lack of encumbrance or information relevant for the prenuptial contract. And we now have an act of the real estate registration. It will be put into effect in January 2013, whereby all real estate deals will have to be submitted to the notary office to be notarized. That shows that members and participants in civil relationships are very active, and that tells you that notary offices are very active, and that individuals and companies alike trust the notary community. Another thing about our legislation I would like to touch upon. We all agree that Notariat is a public institute. At the same time, the Kazakh Notariat is not wholly a public institute. We have a decree issued by the Constitutional Council whereby the Kazakh Notariat is both public and private by nature. It is not a 100% public institute. When the most recent changes were introduced into the Notariat Act, we did not define Notariat as a wholly public institute, and the only thing we could do, we changed the name. The definition of Notariat is in Kazakhstan. And the definition that was developed was that it's a legal system or a legal institute assigned to provide skilled legal assistance. So that now is a constitutional responsibility of Notariat to provide higher level legal assistance, and that is something we never had before as part of our legislation. We also developed requirements to be met by notary officers. The minimum age is 25. The practical legal experience is at least 2 years. Working as an intern is at least 1 year. A successful legal exam, membership at the notary chamber, and re-evaluation test. All those requirements can be found in the Russian legislation as well. Yesterday and today we've been talking a lot, and I've had the same question. How come that there's no longer limits for the size of the notariat community, for the number of notary offices? Here I'd like to express my special gratitude to the Federal Notary Chamber for helping my country to develop the legislation, specifically to Mr. Yurkov, Medvedev, and Ms. Nikolaeva. They came to attend a conference at the Kazakh parliament when we discussed the amendments and tried to convince our parliamentarians and the governments that they shouldn't lift the limits for the size of the notariat, because that might affect the economic well-being of the notary office, and if they lose that, they will lose some of their benefits as a worker. Galina is here. She attended the conference. The Ministry of Justice offered their arguments. They said that there were problems associated with the qualification exam. Number 2, that 2,500 notary offices with licenses should be given enough jobs and enough work. They made a reference to the Constitution, whereby every person is entitled to a job or to labor. We couldn't my chamber, couldn't convince them, and the amendments came into force on the 16th of January. Now, as for the rates shall be regulated by the government. The rates are fixed. The rates consist of the government part and special rates for special services. We had a bill on notary rates, but the government decided to separate them into two parts, like government duties and the service rates. They are the same across the whole territory of Kazakhstan. As for rural areas, I can assure you that rural areas are fully covered by notary services. There's no problems in that realm. Of course, we assume and believe that as the quantity ceiling was removed, there'll be an outflow from the rural area. But so far, there's been no complaints from the rural areas. We're going through a process which hasn't been finalized. At this point, there has been one single notary office in the rural area who decided to transfer to a city. I had a discussion with my colleague from the Ukraine, and they've had that since 2007, and we expect it to happen. We expect this rural outflow of notary offices to occur. On the 27th of June, Kazakhstan is going to hold a conference which will be featured by all government stakeholders and lawmakers. They will make it a point that we should go to the system where there's a ceiling for the number of notary offices, because once again, the absence of the ceiling will have a negative impact on the social and economic status of notary offices. Let me reiterate now that Notariat is an instrument of economic development, social stability, and litigation prevention. That is why the Kazakh Notariat seconds all of the opinions and conclusions here, and thank you very much for your patience.
Thank you so much for a very interesting speech. I do hope we'll have enough time for the discussion, and I hope we'll have some questions from the audience. I hope we'll have time for that. We heard about the experience of a country that wants to be adapted to the economic reality and needs of economic development. I do understand your aspirations, and I do understand all your difficulties in terms of regulating the number of notary offices and a number of difficulties that arise there. I do understand that all this should go in line with the economic development of the country, and a number of important decisions should be made in this sense. I hope these important decisions will be elaborated on, and maybe our colleague from Germany, the notary officer from Bavaria, can help you in this. Please share the German experience with us. Dear colleagues, the topic of my presentation is the role of notary officer in corporate law and in economy. Let me start from saving up our time. We'll speak Russian, and since the majority here understand Russian, we'll save a few minutes in my presentation. So I'll try to fit in 10 minutes. The objectives of my presentation is not to tell you about the role of notary officer in the corporate law, especially in the German corporate law. I will dwell upon a few constituent issues, and I will explain them on the examples. The thesis are as follows. The typical system of preventive aid, which is a Latin type notariat, underpins legal stability. This concerns the German corporate law as well. The legal stability, last but not least, is ensured due to a number of regulatory forms, including the notary forms, that can seem bureaucratic and too bulky in the beginning, but if you look at them thoroughly, you will understand that they are the foundations for the stable relations between the companies and entrepreneurs. Initially, the tough norms bring due to the more facilitated resolution of different disputes and situations, and due to this fact, a lot of disputes are settled before they go to the court, and thus we save up and we offload our judges and courts. The settled norms also contribute to the following things to happen: decrease of load on the governmental authorities due to the preliminary control, as well as the review of the agreements, so on and so forth. The relevant documents, we have the probatory or evidentiary function, and we have the archive function, because the documents are stored in the archives. Consultative function, and our colleagues mentioned it at the fora. In middle-sized business, notary officer is evaluated as a consultant because he is available in terms of the fee. Secondly, he is qualified enough because he was qualified by the government to do his notary job. And for many entrepreneurs in Germany, it saves up the costs and because they don't hire a lawyer, they rather go to the notary. Ms. Sazonova said that the tycoons do not need notaries, but the majority of other entrepreneurs do need them. And last but not least, the state control and struggle against crime is also a function of a notary officer. For example, notary officers should inform the police about the fraud fact, and the identity of a person is verified by a notary officer to eliminate the probability of fraud. In this way, notary officers promote the stability and sustainability of the society. To sum up the above-mentioned thesis, I would like to show you the main bodies of government and state registration. The specifics of the German registry office is that having one look in the trade register, you can identify a person who has the necessary relevant liabilities and specific liabilities. By familiarizing with the trade register, which is available on the computer, for a small fee you can have an access to the trade register and identify who are the entities, persons in the company eligible to put their signature in the contract. In legal systems, without this type of register, very often you have to turn to the lawyers for having a legal opinion. And in the United States, for example, a legal opinion of a lawyer might cost you tens of thousands of dollars, while in Germany, the goodwill participant of a deal can rely upon the record in the register. in the register. That's why the constituent norm of Article 15 of the Trade Code of Federal Republic of Germany sets forth the positive and negative effects of registration. In case of a dispute, the goodwill third party participant of the deal cannot be sued because of the lack of knowledge of the facts of the registration in case they are not included in the register. And on the contrary, the facts included in the register and published are considered to be the true facts. These facts are eligible in terms of every third party. It means basically that every goodwill participant of the deal can rely upon the register, and he knows that every director who is enlisted in the register has the right to do so. You cannot file a claim and say that the registered executive director was appointed as such in an illegible manner, or he has already been fired, or his liabilities have been changed in the company, because the relevant remark was made in the registration office. As different from the British register, the legal entities in Germany, not all the data from the companies are entered in the register without checking the content in Germany. On the contrary, any piece of information should be included in the register after checking, and this check is done by a notary officer. Notary officer in this sense acts as a filter. Due to his professional skills in corporate law, he helps the experts to do the right wording of the documents, and he helps them to submit data in the registration office. Also, the notary officer is identifying the applicants, and thus he is preventing the introduction of the fraud data. I think these ideas are very familiar from the Anglo-Saxon legal practice. And finally, the notary officer sends data on a protected e-line to the trade register. The trade registers are maintained by the local courts. Due to this fact, the highly professional and well-trained lawyers, after the preliminary data processing by the notary officer, submit the data for the final control. In this way, every piece of submitted information is controlled by at least two experts, a notary officer and a judge. Due to this, we ensure the truthfulness of the information in the trade register. However, the goal of a German notary officers on corporate law go far beyond that. It's more than just checking and submitting the information for trade registration register. Thus, for example, the establishment of open joint stock companies and LLCs are also among the competences of the notary officers. All the changes and amendments in the bylaw of an open joint stock company must be verified by a notary officer. A notary officer participates in the meetings of the company and then submits a new version of the bylaw or the charter to the trade register. Due to the mandatory verification of any amendment in the bylaw, any disputes in the corporation, in the company, are excluded concerning the contents of the bylaw. All this is done to protect the interests and to ensure legal stability of the processes. Besides, any submission of shares, any changes in the shares of open joint stock companies must be verified by a notary officer. After the reform of 2008 in Germany, a notary officer who verifies the transfer of a share of participation in the company has to submit the new list of participants of an open joint stock company. In this way, he updates the new list and the criteria of goodwill are observed. The role of a notary officer was substantially strengthened by the German legislation within the framework of a large reform since the adoption of the law on the Federal Republic of Germany. In this way, a German regulator prior the World Bank and economic crisis set forth a signal against preventing us from deregulation. It's better to provide everything and even more than to be left without any competences later on. By doing this, by giving notary officers all these functions, we promote the stability of legal relations. Hereby, I would like to conclude my speech. Thank you so much for your attention. Thank you very much for your really interesting speech. We could see a very pragmatic concept in your presentation. And yes, indeed, we have to conform to the economic realia and needs of life and to build up our professional community in such a way so that we could conform to economic realia. These realia are of a globalized character, and taking into account the international context of this process, we need to understand the functions of our notary profession because it's getting globalized as well. I would like Mr. Pasco to tell us about it, and let me kindly ask Mr. Pasco not to exceed 10 minutes in his presentation because we have other speakers who would like to make a speech. Mr. Pasco, go ahead, please. Dear colleagues, dear colleagues, it's a great honor and pleasure for me to take part in the second such a prestigious forum, not only because it takes place for the second time in this city, but also because, as we can see, our relations are getting more and more international and global. So it's very important to meet other lawyers from different countries and to compare our experience. Let me now speak in French, since I know we have great interpreters here. I was asked to talk about the difficulties we face in our profession from the viewpoint of in the international context. And as we can see, we are more and more frequently facing the challenges of a legal nature, and they have a lot of elements of internationality. It can be the citizenship or location or property. So all these situations with foreign component could have existed initially. For example, a Frenchman marries an American woman, and then they choose to live in Germany. And then one of them dies. Which legislation will be enforced in this case? These situations cannot arise immediately, but in the course of time. For example, a French couple marries, and then they decide to live in France. And then, for professional reasons, one of them moves abroad, or she moves abroad, he moves abroad. Which legislation will be eligible here in terms of some probate proceedings? In this way, we can see that the notaries have to understand the law enforcement and the system of which country should be applied to this or that case. In order to apply the French law, according to the French legislation, we need to have a few criteria in place which are worded in our French law. When talking about the property, we talk about the link to the real legislation. It means the legislation in the country of location of this property. When we talk about the personal status and the eligibility of a person, we talk about the personal law, which in terms of the French law is identified for according to the citizenship of that person. If we're talking about the legal facts, then the situation is interpreted and linked to the legislation of a country where this or that legal fact takes place. When we talk about the procedural issue, of course, the law of a country where this or that claim is being considered will be applied and eligible. As for the rules for those who live in France, they are impacted by the labor law, tax law, and civil law. Every country has its collision rights. I represent the French system, and we have discrepancies here. In this sense, I would like to consider an example of an Englishman who lives in France. The eligibility of this Englishman with the consideration of the fact that he lives in France, according to the French legislation, will be determined by the British law. But according to the British law, this criteria of linking this person's proceedings to the location should be done locally in France. In this way, we have a legal discrepancy, a legal collision. A French law does not always underpin certain procedures. The British legislation is just is just taking this issue to the as a prerogative of British law. As for the circumstances of law, for example, or probate proceedings, this law is enforced specifically. As for the agreements and the property relations between the spouses, this principle of linking legislation to locality is not deployed. In this way, we can see some difficulties a French notary is likely to arise because to come across, because he might come across the difficulties he doesn't know about. Yes, indeed, the previous speaker was talking about the legal opinion, or what we call a certificate of regularity. It's a lawyer who works under the international law. In France, we developed, and as far as I know, we have the same in Russia, we developed special centers, R&D centers, that help the notary officers to get consultancies on this or that issues and to get a qualified answer to their questions. Besides, we conduct forums and seminars where the experts from different countries participate.
Where we meet each other, and that helps us take care of the issues I have described. It is pretty often that I face a situation where my colleague, who knows that I am a coordinator for Russia, comes to me and asks me which of the Russian colleagues he could get in touch with to cover a certain issue. That's why such international events are so important. There may be other problems, because this foreign law, which French notary officers may have to apply, may be incompatible with the public order. For example, having a lot of wives is outlawed in France. In France, you cannot marry more than one woman, while in a different country, you can marry as many women as you want. And then the French law decides that it should apply to France. If a person lives under the French jurisdiction, right, so it may lead to pretty complicated issues. Besides, there may be the so-called mobile conflict, a conflict of mobility. Two different legal systems may collide. Suppose you have two spouses, Maltese, and they are married. They seek French citizenship and then they want a divorce. They can't do that under the Maltese law. Of course you can't do that under the French law. So in that situation, will the two spouses be considered as people who married each other in Malta? Will the Maltese law apply to their situation, or because they are currently living in France and seeking French citizenship, it will be the French law that will apply to their situation? There's this concept of the interim law. When the situation is developing, you can't change the past, of course, and that is based on and linked to the past law. As is for the new situations that arise, the new regulatory system will probably apply. That is how this evolution works. Because I'm really pressed for time, I would like to very briefly discuss the international inheritance, to draw a line between what you have in the French law and what you have in the Russian law. In the French law, you have this distribution into the shares based on whether you deal with movables or immovables. You don't have it under the Russian law. If you have any questions, I'll be happy to take them, but I really have to stop, and thank you very much. I'm really sorry for interrupting you, but I would like to use my authority of a moderator. And let me now invite a person who's joined us. He's Deputy Chairman of the Defense Bar of China. China is a country we all are interested in, and it is with great pleasure that I'd like to invite and welcome my colleague here at the podium. Thank you so much. My dear colleague, you, like I said, touched upon very interesting issues concerning the rights of foreigners. And that was a follow-up of the subjects introduced by my Swiss colleague. What you said demonstrates the importance of legal security regulation. It also illustrates the fact that the market is not limited to the money. The market means people, and people have some fundamental rights. The market may only develop if the human rights are respected. It would be great if the market economy could always respect human rights as it develops, the right of every person, and here notary offices play a key role. And here we are very interested in the experience of our Chinese colleague, but before I give him the floor, let us listen to our colleague from Kiev. Let us listen to our colleague from Kiev. The human rights in Ukraine are protected, among other things, by private and public notary offices, and they cover all groups of rights. Under the Ukrainian law, Notariat, protecting human rights is a responsibility of a notary officer. It's not his or her final goal. But even though legislative definitions are not from being perfect, notary offices have a lot of opportunities to protect human rights. A notary officer acts on behalf of the government, and as such, the notary officer certifies facts, rights, and documents, and the notary officer offer legal assistance in a wide range of different issues, and that service is not limited. Legal assistance can only be limited by the professional level of a notary officer. What are ways of protection? Well, in addition to law enforcement activities or certifying deeds, dealing with issues of inheritance, protests, the notary officer plays an instrumental role explaining to the people how they can exercise their rights. Protecting human rights does not begin with the Notarial Act. It begins when a person comes to the notary officer. The list of notarial services is introduced by the law of the Ukraine, while legal assistance is a multi-vector area. The most significant, the essential part of the legal assistance is consulting. The notary officer has to do legal review of the problem, identify possible solutions, explain the law, develop a package of documents. As part of consulting services, the notary officer carries out an essential function. He or she examines facts and circumstances, and very often the consulting develops into an ethical area. The mere fact of the notary involvement is important. Efficient consulting services can't be rendered without forecasting or modeling. It is the notary officer's responsibility to model possible future developments, come up with a forecast, and describe a possible future development of the problem. It is very important to try to forecast or predict the reaction of other people who are linked to the notary officer's client. In most instances, the client comes to the notary officer and describes the problem, and he doesn't know what notary action should be made to protect the client's interests. It is the notary officer's responsibility then to think about this issue, translate it into the legal language, identify the goal and the solutions. In the Ukraine, the notary officer is also an educator. Notary officers have access to electronic registers, and they can issue accepts of the registers. Legal assistance can take the form of registration in different registers, like the alienation prohibition register, mortgage register, the assignment of rights register, inheritance issues, probate issues, probate certificates, etc. The reporting system can't be overestimated, and the register system can't be overestimated, because registers have a complete body of information in the Ukraine, helping the notary officers establish rights and facts. As part of the legal assistance, the notary officer explains to the citizens what their rights and responsibilities are. In doing so, the notary officer is indirectly involved in citizens' self-protection. Likewise, the notary officer assists individuals in the interaction with the government, because it is his or her opportunity and a right to request documents. That kind of legal assistance is especially important if you have in mind that bureaucracy can be overwhelming. Legal assistance may take the form of refusal to commit this or that legal act if the notary officer comes to the conclusion that notarization can harm the client or a third party. Even though the legislation does not directly defines the notary officer's responsibility to prevent conflicts, a notary officer can be somebody like a mediator. What is especially critical in terms of prevention is the educational role of the notary. The notary officer explains prohibitive statutes and other statutes. Like I said, the notary officer does certification, does modeling, does prevention, does education. It deals with all kinds of agreements, prenuptial, alimony, probate, gifts, lifelong support, etc. Notary or notarial prevention is a way to monitor the rule of law. What is a notary mediation about? It is about the settlement of possible disputes and conflicts. The notary officer makes a very good mediator because of his or her impartiality and lack of interest in the outcome of the case. Actually, well, the principles of mediation are very close to the principles of the notarial equality, impartiality, transparency, voluntary nature. Ukrainian notary officers, as mediators, deal with the settlement, transfer of debt, property division agreements, changing inheritance shares, changing the order of inheritance. The notary officer also carries out mediation functions in introducing changes into the probate law. And now let me make a couple of comments about a very important aspect of notarial protection. To be able to protect human rights, the notary officer's rights should be efficiently protected legislatively, socially, logistically, etc. Like our mediator said, the Ukraine now is facing a serious problem. We have 5,558 private notary offices, and we have 839 private notary offices with 2 to 5 notary officers working there. The maximum size of the notariat is even higher. For Kyiv alone, and Kyiv is a city of approximately 4 million, the ceiling for the number of notary is 49,400. Such status quo violates a fundamental principle of notariat. Because the idea to increase the number of notary offices was to make people's life easier, to help them have an easier access to notary offices, but such measures created a lot of problems for notary offices. Number one, tough competition, which creates a big question mark for the economic efficiency of notary officer. It makes them life very difficult to them, and it makes it very difficult for them to exercise their creative potential in full. The economic crisis resulted in a decreased demand for notary services. The big question is how good or bad competition is for the notary system at all, because we are not private service providers. Notary offices have a lot of problem with retirement support, pension, taxation, social benefits. The Ukrainian parliament currently is discussing bills which have to do with the notarial system. The bill has plans to unify the remuneration for the notary offices, to make the notary union a professional organization, and the notary offices will probably get the functions of government real estate registrars. We can't wait to have the law, because that responsibility, that function, will make our life as well as the life of people much easier. The Ukraine is very slow in understanding that a notary officer is not an auxiliary person. That's a full-fledged and unique person who is as instrumental as a judge or an attorney in protecting people's rights. But it is only possible if the notary officer's rights are protected, and that includes, above all, economic rights. Without that, we can't expect notary officers to be efficient in providing their services. Thank you. Thank you very much. Thank you. You made a very exciting presentation. You did a very good job describing the situation in the Ukraine. And of course, we understand once again what services your notariat can provide, and how the notariat is instrumental in protecting people's rights, and how it is necessary to protect notary officers themselves, because unless the notariat is protected, they will not be able to carry out their functions. Everything is interrelated in this area, which is why we'll have the presentation of the Deputy Minister of Justice of China. We'll ask him to speak about the development of notariat in this gigantic country. Thank you. I'm going to speak very briefly about the Chinese legislation on notariat. And of course, it is based on the Soviet model more than anything else. In 1949, we adopted Chinese rules. In 1959, there was the Cultural Revolution, and the notariat slowed down in its development. In 1967, we once again reintroduced notariat. In 1982, the Government Council issued a decree on notariat. In 1981, we created the Notariat Act for the first time. We have 3,007 notarial offices, and we have more than 10,000 notary officers. 2,700 notary offices were created in other countries, and our demand in notarial services is quite well met. The Chinese notariat is based on the continental or Latin legal system. We all are members of the Notarial Association. It has to be emphasized that the economic role of the notariat is extremely critical. There's 4 components to that. Number 1, the notariat dramatically improves the system of resolution of social issues in China. Notariat has a preliminary protection function. As such, it promotes commercial activities. The Chinese notariat is broad. We have more than 3 million notarized deeds a year. That contributes to balancing the relations between different parties and prevents violations of the law. Number 2, has to do with protecting people's rights. That is a critical function of the Notariat. Chinese society is going through transformation now. The essential issue has to do with the lease of land, enterprise reform, environmental protection, human rights, etc. Over the past several years, the Chinese Notariat has been at the front line. We address a lot of issues, promote societal stability. Number three, the Notariat is going through reform and many structural changes. The Notariat has a critical social role. The government guarantees the work for the Notariat. We have a fundamental legal basis for the Notariat. Number four, the Notariat in China contributes to the country being more open and global. The Chinese reform is getting deeper. And there's a lot of exchanges between Chinese citizens and foreign citizens. We have a lot of tourists, and we know that there's a great number of people coming to visit our country. We have more than 3 million notarial documents certified in China, and that creates a powerful foundation of the Notariat. Dear colleagues, to improve the economic and social role of the Notariat, the government has been very busy improving the legislative support for the Notariat. The legislative aspects are getting broader, and that includes financial and tax elements, and the same is true of notarial cadres. Thank you very much for your patience.
Thank you very much. Taking into account that we have Benjamin Yakovlev, the advisor to the President of the Russian Federation on legal issues, is here. And since he's going around all the workshops, all the sessions, we'll take advantage of him being here, and we will kindly ask him to say a few words. Thank you so much. Yes, unfortunately, I have not enough time to sit and listen to all the presentations here, although I'd like to do so. It's a pleasure to see many colleagues, not only from Russia, but also from overseas. Thank you very much for coming to this event. I guess that the Russian audience knows very well that at the moment we have a very important moment which determines the future of our notariat, because in the State Duma the draft law on the introduction of changes to the civil code is being heard, and besides, a new draft law on notariat has been developed, and I consider these two drafts as the leading package reforms if the amendments to the civil code concerning notariat are going to be introduced. Then in the foreseeable future, this will determine our work, because the registration of real estate deals in the Russian Federation is a huge work work which is successfully tackled by Notariat. However, we are likely to face some reforms. We have very strong opponents, I would say, and they are lobbying their opportunities. They have great lobbying opportunities, and and of course they would like to argue about this disputable issue, such as the verification by notary officer of the deals related to the real estate. So I believe that all the religious notary officers must pray for the amendments to be adopted. All the non-religious persons have to use other means to cheer for this draft amendments. Well, why? Because not because the notary officers need it, but because the Russian citizens are in need of this. I am deeply convinced that our society is in a need of these reforms, including the ones who are our opponents currently. They are just misled and they do not realize that they need these reforms. I hope that eventually it will happen. Of course, things are not done overnight, but Notariat should be transformed through a number of mechanisms to be brought in line. Insurance, liability, you know it very well, much better than I do, because this is your daily work. Well, I wish you every success in your work, and let's wish each other a general success in our general job, because I do hope our State Duma will be wise and they will adopt the crucial decisions for our society. Thank you so much for the opportunity to speak in front of you. We are conducting a round table and a conference tomorrow on the modernization of civil code. We'll have a hard day tomorrow. You are invited. Please come and join us. We'll work together. Thank you very much. Well, we are about to deplete the agenda of our roundtable. We listened to many interesting speeches. Representatives from different countries held presentations and speeches. We even mentioned religion, and the last but not least speaker is Mr. Jean-Michel Decor, the president of the International UNIL. I don't know his attitude to religion, but he can talk a lot about the Notariat. Thank you so much. I'm a religious person, but I first of all believe in the common sense and in the trust to the notary officers. I would like to talk about the role of notary officers in the system of continental law in ensuring legal security, and which is crucial for the development of modern society. It's crucial for the relations between state and the citizens. It's much more important than the relations between the citizens and the notary officers, and all this impacts the economic development of the country for sure. Without any doubt, the economic development at the moment is going hand in hand with globalization process. It's much talked about, and it brings about legal and social confrontation, and it changes the behavior of the citizens in what concerns their attitude to the state. And people less and less are understanding what is the government, what is the state doing, and what is the role of a notary officer in all these processes worldwide in order to facilitate the job of the state and the challenges of the citizens. So what is its role in economic development? First of all, a notary officer must be really keen on the processes of globalization and market economy regulation. In the social aspect, in our relations, in his relations with the citizens, a notary officer should serve to the common interest. A notary officer, from economic perspective, acts as an economic regulator. Everybody knows what can the uncontrolled globalization and liberalization of economy result in, as well as the systemic deviation from economic norms may lead to grave consequences. Why did we come to this recently? Because of the two faults. One fault was the confusion of freedoms and liberalism, because they are often interpreted as synonyms, while these are antonisms. Liberalism is the absence of rules. It's the law of the strongest, the law of the jungles, open doors for criminals, and the oppression of small enterprises, and the development of a huge economic network that contradicts the economic norms, while freedom underpins rules, because freedom without rules cannot exist. My freedom ends where the freedom of my neighbor begins. So, respectively, in economic relations, it is possible to have a normal coexistence only if we have particular rules in place. It will be wrong to say that the market economy must not be regulated. We cannot imagine a situation when self-regulation can solve all the problems, and the real economic crisis and the current economic crisis is but a witness to it. So in this sense, the notary officers should work in two directions. Number one is to participate together with the state in the development of a particular legal proceeding, legal set of norms, and to control the work of the state in terms of its legislation. The legal regulatory experience of a notary officer is an experience of a practitioner who is in constant touch with the population, and as Mr. Yakovlev mentioned, notary officers are constantly providing consultancies to the population in any country. The second area I mentioned is that the notary officer should be a partner to the state. Any state has its limits. A state cannot do everything. It's not almighty. They cannot do everything. They have their limited resources. So these gaps of the statehood are used by the market actors, by huge transnational companies to promote their interests. But the state must be doing the main things, the main job, such as defense, education, healthcare, justice, and to ensure the common interests of the society, the political, economic interests, but also it needs to transfer its liabilities to other institutions. And it is not by chance that in a number of countries, in the vast majority of countries, the real estate sector is being regulated through notary offices, because it ensures the transparency, the control, because you know very well who is purchasing and what is he purchasing, where is the money coming from, so on and so forth. So we believe that one of the main areas is to attract notary officers to this work, because if a person is enabled to verify his rights of ownership through the verified document, you cannot say that he owns a property. It's the same as your passport. Your passport is identifying, is your identifier. So in this same way, in a similar way, it allows to protect the security of food supplies worldwide, and this is a very important issue. A notary officer on his level and in his role should ensure the control over the violations of these norms, either from the perspective of the citizens or from the perspective of the state. We do understand that the modern laws and legal norms are getting less and less comprehensive for the people. And this prevents the people from applying these laws and having an easy access to the legal aid. Everywhere in the world, Notariat has a triple answer to this challenge. Number one is a geographical answer, because a notary officer links a territory into a unified space, because notary officers work everywhere in rural communities, in large cities. Secondly, the tariff policy of Notariat should be as alike everywhere, and Mr. Reno was talking about it, and the tariff policy should be identified by the civil and legal security norms. And the third function is the responsibility of the notary officer on verifying different acts and documents. In this sense, a notary officer is acting in his main role. The next area is the resolution of disputes. The trends of our times are making disputes more and more frequent, and I don't think there are people who would like to participate in the resolution of disputes, but the number of disputes is increasing on and on. And a notary officer plays a key role in this area as well, by linking different state systems. A notary officer is the element that acts as a preventive measure in the system of justice. A notary officer is like an arbitrary officer in the resolution of disputes. And due to his unambiguity and the power of the evidence base is a key factor in the resolution of disputes. In this way, in terms of economic development, the role of a notary officer can hardly be overestimated. This is a well-organized, competent profession which responds to the fundamental needs of the society and takes into account different trends of the development. A notary officer acts as an intermediary between citizen and the state, and no wonder that everywhere in the world, and even in the Anglo-Saxon system, people are in need and societies are in need of notaries. In more than 10 countries of the world, want to become members of UNIL, and we do welcome their initiatives. China and Korea want to be part of our organization. Notary officer is a contemporary modern profession of the 20th century, and notary officers serve the statehood and legal security. Mr. Medvedev, the Prime Minister of the Russian Russian Federation told us about it yesterday, that notary officers serve to the citizens and their happiness and well-being worldwide. Thank you for your attention. Thank you so much, Mr. President, for your illuminating speech and the high-level understanding of issues. I think you expressed the opinion of the majority of the speakers today. Thank you very much for your explicit presentation and speech. Thank you so much. I would like to thank you, all the speakers of this session. Thank you very much, dear audience, for your patience, and thanks for listening to all the speeches. We're open for your questions. We managed to have quite time for discussion and Q&A. And my colleague from St. Petersburg is here, and I know that from the scientific point of view, you were actively participating in the development of notariat reform in the part of notariat satisfying the economic needs of Russia. Couldn't you make a comment, please?
Thank you. Thank you, Marie-Yvonne. You've mentioned my name a couple of times today in a positive context, but it would be inappropriate, not impolite, but inappropriate to take it as a personal comment. We all realize that in a scientific area, one person alone cannot achieve impressive results. So whatever has been done in this area can be and should be attributed to my colleagues from the Law School of St. Petersburg State University, who joined in the efforts around the Notariat Institute. They're working very closely with the Russian Notariat, so your nice words should be readdressed to them. As I've been here listening to the presentations, I realized that everyone concerned about the same set of issues. Most of the issues I would like to focus on if I had to undertake such a difficult role and make a presentation in front of this wonderful audience. All those issues have been raised, and I would like to ask you the questions I keep struggling with. The questions, the answers to which will probably introduce some clarity into the issues we have discussed. The questions I have developed, I'd like to apologize up front, because I was writing them down as I listened to my colleagues' presentations, and they are not necessarily as clear as they may be. The questions are probably caused due to some criticism of the notariat. As soon as you hear some criticism, maybe your first reaction should not be to put up your shield and try to defend yourself. You should probably think about the root causes and try to deal with them. Any criticism always gives you a chance to improve yourself. I put aside the criticism caused by the corporate fight. Let me put it like that. It is quite obvious that now that Russia is trying to develop a practically new civil code and an absolutely new Notariat Act, there's been a lot of criticism coming from attorneys and lawyers. Why? It is quite clear, because the market of legal services is being redivided, and it's not about who shouts louder. It's about which legal institute should take which niche in the social and political structure of society. So I put that kind of criticism aside. Another group or category of criticism is related to a very unfortunate factor. Whether it may be found in other legal systems, it is up to you to help me understand. But as for Russia, I'm quite convinced of that. I'm a member of the Civil Law Codification Council associated with the presidential administration, and we are monitoring the quality of economic bills. Every time the council members discuss the bills, we have people from the government, the Ministry of Economic Development and Ministry of Finance come and take part in the discussion of the bills. We have judges come to our council. It is a very representative body, take my word for that. But at first, I was embarrassed, and then I was concerned to realize that many lawyers have a problem understanding the nature of notariat. And some of the arguments, some of the comments I've heard testify to precisely that. For example, what is lack of limits for the size of notary offices in the country? It tells me that the authors of such provisions don't understand that the notary officer and an entrepreneur are two mutually exclusive figures. As soon as you start having the elements of competition in the notariate system, as soon as I'm not talking about professional competition, I'm talking about entrepreneurial competition. As soon as you have this kind of competition on the market, what you do, you have the notary offices cut off the branch they're sitting off. And the whole society suffers as a result of that. As soon as you have competition, you immediately have what? Advertisement, revenues unrelated to your rates, taxation considerations, and of course the tax authorities step in and respond to that. That is one, extreme misunderstanding. And the other extreme is excessive simplification of the notary officer's role. I have to discuss it with many professional colleagues who complain a lot. Let me give you an example. You have this mortgage agreement, and you have to notarize a signature. We come to the notary officer, and the notary officer says, no, why? And when I try to explain to them something that everyone in this room understands very well, they say, no, we don't need that. We only need a signature to be notarized. But you have the whole contract in front of you. No, we only have the signature to be notarized. Why doesn't the notary officer do what I need? And my attempt to tell them that any bureaucrat can certify the signature. Any secretary at a public agency can certify a signature or verify a signature for you. You don't need a high-level professional to do that. And society doesn't have to incur a lot of expenses to verify signatures. Still the problem stays. So, if I may, I would like to know my colleague's opinion, the expert's opinion above all, in answering my question, what is the role and function of a notary officer in society? And I think it has to do with the question you asked. Do we need a notary officer in Russia to certify all real estate deeds or only deeds involving individuals? My question is this: what is the function of notariat in this country? Do they have to act as administrative controller of the turnover? And consequently, the notary offices have to process and purify all deeds, removing the defects? Or does the notary officer have to protect the underdog in the turnover, so to say, the weak party, and the interests of those who want to come to the notary officer to have their deed certified? That was my first question. And my second question is, I only have 2 questions, I promise. Let us try to take the first question, which I believe is essential. What place does a notary officer take? What is the notary officer's role? And what do you think about the system of competition? Does the country's economic development mean that you should have competition in every area? And then it isn't quite clear why we should pay to the notary officer, why we need this intermediary. Because in any situation, if you use an intermediary, you have to incur more expenses, while the competitive market means that service does not cost anything, or if it costs something, it is very little. That's a critical question, the one asked by my colleague. I assume that all legislators across the world ask the same question, whether it is in China, Russia, or Europe. What is the place of the Notarial Institute? What is the place of Notariat? And what is the place of competition in the Notariat? How is it related to the nation's economic development? Should the economic development be based on the competitive market? Should it be based on the supply to demand theory? Is it enough? And if that is enough, why do we need to incur expenses associated with the notariat? Or, alternatively, the economic development can't be achieved solely based on simple rules of competition. And there are some other needs that should be taken into account, and they can justify expenses associated with the notariat system. Those are essential questions. Does any of you want to take those very critical questions which define the relationship between the notariat and competition? Because, you know, the European Commission in Europe, the Commission, which feels very positive about competition, has a tendency to believe that the economic development may be achieved solely based on the availability of a competitive market. However, having said that, Europe today is facing of an unprecedented economic crisis. Who would like to take this question? President Renault? I'll try to take it, because the question is, of course, extremely complicated. There's a lot of legal minds which have been working on that for many years. You mentioned Europe. Yes, that is true. The European Commission, through Commissioners Barnier and Vedink, have been trying to retain control over the situation. But even if the wildest dreams of liberalism, those commissioners can't rule out the significance of the contribution by those whose responsibility it is to ensure political stability. You mentioned the issue of trust at the beginning. If the market is only based on competition, then the strong one will squeeze out the weak one, and then the deed which will be signed is not going to be based on the trust in the quality and security and safety of this deed. That sends a certain signal about the attitude to the notariat, because notariat means additional expenses and additional time. there was a report published in European Business saying that notarial services are too expensive and that they take a lot of time, and that means loss of time and consequently loss of money. I don't share such a viewpoint, needless to say. Well, you need some time to make your contract safer. You may spend some time, but that may help you avoid mistakes. Quality consideration is another thing. Whether it is an individual or a corporation, you have to make sure that they're quite competent to undertake the commitments they want to sign under. Economic security is another consideration. You want to make sure that the payment is a real thing, because there's nothing more fearful than to say goodbye to your property and get nothing in return. We are discussing here the critical issues of market security, market stability. You want to guarantee solvency, and you want to guarantee loan security. You want to understand very clearly that if you have a deposit or a collateral, you want to make sure that the collateral giver is competent. Let's go back to this financial crisis. Once again, it's a crisis of trust. Financial institutions are not sure they'll be able to get back the money they lent. And if you have a transaction between two private parties, the borrower wants to be quite sure that the lender wants to be quite sure that the borrower will be able to pay back. And here the financial regulators step in, and among other people, we need a lawyer who can guarantee that the transaction is safe. It may be certified, verified, that contribution can't be overestimated in terms of its significance on competitive markets. If you're trying to resolve a problem without a guide or a mentor, you can find yourself in a predicament. And if you find yourself in a situation of the economic jungle, of course you want to have an advisor. You want to have a good lawyer who'll be your guide in the jungle. What was your second question, Professor, please? My second question has to do with the criticism we hear so often, the criticism of Russian notary officers. That is when they are criticized for being excessively cautious, on the verge of being bureaucratic, which is insane in opinion of many clients when they require and demand that many documents be rewritten and redone. Let me translate this criticism into readily understandable language. The problem may be that the notary officer's clients criticize them for inability to find a reasonable borderline between cautiousness and reasonable carefulness, which should be the notary officer's best friend. And this apprehension of fear for their future, when something happens, God forbid, and I, as a notary officer, will not have a paper which will help me protect myself from future problems. That borderline, for every notary officer, that borderline means how much work he puts into it, how much nerves he's going to spend. And for society, it has to do with accepting the notariat versus not accepting it. If there is a legal institute which is constantly criticized, that means that you want to improve it, don't you? That problem has a lot of things that have been made up overly emotional things. When you come in, you understand what you have to be done, and then you get upset about every additional request. You know, you come to a certain organization, you are asked to do something, you feel you don't have to ask, and you get really angry. Let me go back to the problem, however. One of the possible solutions, in my view, might be the development or discussion of a summarizing solution. And we in academia have had those discussions many times, not just in academia, but we've had those discussions with practicing notary offices. The question is, what mentality do we want to develop at notary offices? Because I hear too often from high-level, deeply respected researchers that a notary officer is a lawyer with an kind of instructive thinking. The notary officer wants instructions and a sample of a document, and then he'll do a splendid job. And there's an alternative approach where the focus is made on creative thinking of a lawyer. If a notary officer, therefore, is capable of creating thinking as a professional, if the notary officer, of course, the notary officer needs instructions and guidelines and samples he wants to fall back on, but if the notary officer is capable of creating a sample on his or her own, and if the notary officer is capable of independent assessment of the situation based on the law, and let me put it out to you that there's nothing the Russian notary offices are better familiar with than new situations. And this notary officer's habit, well, you know, I sell, you buy, I gave him 1 million and he promised to pay it back to me in a month. Yes, you come across such agreements. But you have some quite unexpected agreements, retrospective, conditional, and notary offices are horrified by them because there's no operating instructions, no sample to rely on.
As far as I understand, and I represent the academia, of course I would like all the notaries to think like our best minds do. The graduates from the masters, with a master's degree. I know that there are more topical and daily issues, but now this issue is very important because the success of the Notariat depends a lot on it. After the State Duma adopts the updated version of the law on Notariat. Here is a question to you, dear colleagues. Do you think we need to educate and bring up a creative notary officer? Or you believe that we should orient the notary officers on the daily routine work, instructions, and execution of the prescriptions and work? May I defend our notary officers, first of all, please? I believe that apart from the absence of creative thinking, today we have objective reasons that prevent notary officers from shouldering the responsibility for the verification of this or that notary act. Reason number one is there is no 100% true data in the state registers, and we know this, and the notary officers know this as well. Secondly, and I would like to ask my foreign colleagues to close their ears. I don't want them to hear it, but until now, Russian notary officers have no official access to the state registers, and they are not eligible to request data from the state registers, which is an absurdity by itself. Number three, since 1995, the notary officers in Russia, diplomatically speaking, they are artificially on the low regulatory level were taken out from the civil proceedings as for the constituent legal documents perspective, what's going on the market, and I share your opinion, Natalia Grigorievna. We already digested the documents, and we can see a lot of agreements coming from the corporate sector on the expropriation of the shares in the capital, and the question arises. So if the right of ownership is registered in the state register, no matter what you have to hear, a notary officer accepts it as a document adopted and approved and registered by the state. And a notary officer is not liable for and is not responsible for this. Today, that's not so. And the notary officer understands that he has been given the conscript from the state register, and he's registered as a legal entity, but in the written agreement he was presented, he can see more questions than answers. How to close his eyes? How can a notary close his eyes at the document, even though he knows that he will face the consequences for verifying this document? May I protect myself, please? Let's differentiate two situations. Maria Ivanovna, you know very well that I am the first person who openly says that if we are entitling the notary officer to verify the deals based on the simple agreements in written form, we need to accept that the government shouldering the responsibility. In the law, it says that the only proof of the right is the record in the register, and we just say that this norm must be deployed. We do not need to invent a wheel here. And if a notary officer has doubts about anything else, of course, he will be reasonably cautious in his actions. But I meant another thing. I meant the cases when any non-standard deal provokes the fear of a notary officer. He fears that he will not cope with this deal, and then he denies it, while people require more freedom. These are the situations I meant. Thank you. Maybe it's more appropriate here to speak about what I began from. We need to transform our mentality. Even the switch to probate proceedings based on the principle heritage sans frontières shows us that a notary officer can always find some causes and say, my computer is not working, go to another notary office, so on and so forth. When in the notary community this becomes a matter of professional ethics, a notary officer will be in charge of this. And two issues should be in place here: the personal responsibility, and secondly, the interaction of the notary chambers to increase the control and regulations. This much about creative thinking. I think there can be no other option here. I didn't violate the principle of the freedom for notaries. What I began from is from the transformation of minds in what concerns these issues. I think that our colleague from Switzerland would like to add a few comments on this issue. Madam Professor, I know what you mean. I understood your considerations. Let me share my professional experience with you. I live in the country of the Latin law, and just like you, I do face this system when there is some cautiousness in actions. I have clients from Anglo-Saxon system, and a question on the change of mentality arises here, because we want people to come to the notary offices, and we want them to be interested in the notary officer services. We know this very well, and we talked about it, and it's very important. It's ensuring this stability and security of the deals. A notary officer, more than anyone else, can ensure this security, and he is the one to shoulder this responsibility. He must act quickly, because we talk about economic resources and economic relations. He should facilitate the actions of the stakeholders and not to make them more difficult. Yes, indeed, a notary is lucky because he is neutral. He doesn't take the position of one of the participants of the process. And the creativity is in finding the most simple and efficient way. In this way you can save your money, save your time, and in this way a deal becomes safe. I would like to finish by saying that there exists a difficulty in this creative mentality, and the reason for that is the impossibility for some notary officers in some countries to exercise the tariff policy in consultancies. In what concerns the real estate deals, the tariffs are quite clear, and the tariff policy is quite uniform. As for the tax area, everything is quite difficult here. It's hard to identify the tariffs we want and we can practice, because there exist some differences in the rights and interests of different stakeholders here. And of course here, what will be the remuneration of a notary officer is quite a hard question. And yes, indeed, we need some rules to be in place for the tariffication, and we need some freedom and a trust in the notary in place. I would like us all to be more pragmatic, because once we are more pragmatic, we will succeed. I think we will now pass to the third issue. Besides, we have an Italian notary officers here in the room, and since we didn't talk about Italy yet, and since this is an international forum, and the international context must be well represented, let me give the floor to our colleague from Italy. Do you have the third question? No third question? Okay. So among us, we have a notary from Italy, and we would like to listen to his opinion. Well, this is not a questioning.
Merci Madame la Présidente. Et donc, je voulais surtout me féliciter pour
Thank you, Madam Moderator. I would like to thank the participants and the organizers of the event for the high quality and high level of the discussion. I would like to mention a few things. I will not touch upon all the topics discussed here. Let me just make a brief comment on what concerns the issue mentioned by Madam Professor. She mentioned the problems related to the new version of the Civil Code of the Russian Federation. I want to say that the topic you mentioned is the topic which even in Italy until now is discussed with a great interest. I believe that you understand very well that in Italy the tariffs are fixed for the notary services, and just like for all other professions, the law underpins that the tariffs are not fixed. They are a result of the discussion between the client and the notary officer. I don't know if it's the recent change in the legislation, but from my personal perspective, I would like to say that in the beginning, I refused to verify an act which I was supposed to verify. I told the client that in this particular situation, it was a very complex act for a limited amount with many stakeholders and with a property, shared property, and I said, I'm sorry, I'm not capable of telling you in advance which tariff I might likely apply here, and please do not ask for any further consultancies on this issue. I should say that in my practice, it was the first case when I faced the need, the realia of the new mentality. Though I share the concerns of my colleague, Russian colleague, I would like to say that sometimes it's very difficult to explain to the politicians, policymakers, and to mass media why the competition cannot be spread throughout the entire segment of notariat. Today, the rules of competition are applicable in all negotiations, in all types of economic and professional activities. These are the rules that are the baseline, the constituent part. But in my opinion, and let me tell it once again, this rule is not applicable to notariat. Nevertheless, it seems quite an obvious circumstance. However, it's very hard to explain it to our politicians. I want to say that the same problems exist in other countries as well. So this allows me to overcome some awkwardness and concern about the notary problem in Italy being purely Italian problem. I can see that it's pretty much international. One more thing to mention is that a notary officer controls the contents of the act and not only verify the signatures. Of course, this is a very important element in the notary job, and it's very hard to explain it once again to some other colleagues, to Anglo-Saxon colleagues, for example, and it's hard to explain it to our clients as well, because they say, all you need to do is to verify my signature. I'm here in front of you. Please, let's do it quickly. Let's verify and verify this signature quickly. And to me, this is a very important experience. And to my great interest, I learned that in other countries, there are concerns, similar concerns, so we share your concerns. We, the notary officers of Italy, are also concerned about the tariffs and also the problem of functions. Because if we talk about the verification of acts, of course the lawyers can do it, why not? Our role is really important here, and I don't believe our functions are different from those of lawyers. Thank you so much for this opportunity to make a presentation. If I may do it with your permission, I would like to make the following conclusion. We can see we listen to our colleagues from China, Germany, Switzerland, Italy, Russia, and we can see that the problems we can see that we have a lot of common problems, and we need to solve them together. And I should say that there are countries that haven't yet created these systems, and there are countries who have already created these systems, and they survived through the crisis. And since Europe, which for a long time now established and set up the institution of notary offices, and Europe is a region which faced the crisis. In this sense, Europe is not ready to say goodbye to the notary profession. And today, different regulators of the market are getting more and more important. And what Mr. Decaux mentioned, and let me refer to his remark, he said that notary officers are treated as intermediary actors on the market, and they ensure the legal security. They are, in this sense, acting as regulators. And once we understand that notary officers are economic regulators as well, Europe then should get rid of the idea that competition is priority number one, and it needs to adopt the concepts that are standing beyond the competitive field. I mean the regulation as applied to the finances. Real estate market is also important here. Here, for example, we have a grave example of our Spanish colleagues where they had grave problems on the real estate market, and as a result there were some issues arising on the financial markets of the country, and we never know what will be the end of the Spanish situation, because probably the Spanish default
can result in destroying the Eurozone. Possible consequences are really serious. Therefore, Europe has to admit that competition is all lovely, but we need regulators. Regulation is more critical for us at this point. That is the stage Europe is going through now. And as Europe adopted regulations in 2011 and 2012, that was what it took into account. Countries which are legally younger say that, well, at the end of the day, we may be quite content living in the world of competition without any intermediation. But then there's a country like China where administrative traditions are quite strong, and where leaders argue that they will retain a lot of regulation in a market economy. The regulation may be administrative or notary-based. I'm hoping that I did not distort what my Chinese colleague said. I'm watching the banking and financial European situation very closely. Let me put it out to you that no one there believes in pure competition. Europe paid thousands of billions of euros for that, and the result may be a collapse of Europe. No one wants to pay such a horrible price any longer for the ideology of competition, and that is what happened in the UK. Countries outside the European area or Eurozone, the countries which live in a world where demand and supply are efficient to regulate the market, where the market is self-regulated, those countries will have to pay a high price for their market and social position of their citizens. That is what has to be taken into account as you reform civil law. Bravo. Once again, I would like to go back to the issue of competition and tell you a story. Once I had a meeting with the European Commissioner, and I said, Mr. Commissioner, under what democratic principle, under what popular decision is the principle of competition in the European Union better adjusted to ensuring people's well-being? Commissioners are not elected. The Commission is quite isolated, living in its ebony tower or glass tower, but he couldn't answer my question because the principle of free competition does not have any democratic legitimacy at all. I often repeat that facts are quite stubborn because the facts constitute reality. If we make a mistake selecting a certain political or legal orientation, this evil is going to turn around and strike back. Because once again, facts are quite stubborn, and you have to take into account your reality. What Ms. von Roche said, what you feel in the economic and financial status is something we see very clearly as notary officers. Because ideologically speaking, ideologically, not pragmatically, our status has been threatened, criticized, attacked. Let me mention one aspect, one thing, which was left out because we were too much limited to the economic considerations. No matter where you work, you have to be aware of professional ethics. We have two impressive advantages helping us to develop our profession, and that is shared by notariats of all countries. Number one is this professional level, professionalism, which helps us meet our clients' demands, and number two is trust, because trust is necessary for economic development, and trust is something that you have in deontology. Some countries, which I'm not going to mention right now, the development is directed towards liberalism, in some others towards abuses, and the reason is that at some point professional ethics were disregarded, or the adjustment of the notariat went poorly, the adjustment of changing political realities. One country, which I'm not going to name, was the country where the government said we have to promote economic development by increasing the number of notary offices. That is precisely what some other countries are doing. France is creating about 100 notary offices annually, every year. So in that country, the political response or reaction was double a reduction of the rate to be paid. That's the reality. And if we forget about professional ethics, if we forget about the rates, if we don't want to adjust to the changing world, our profession, our community always has to pay for that. If I may, Ms. Professor, I'd like to say once again that I'm happy to see you again this year. 2 years ago, we discussed the civil code, and among other things, we touched upon the limitation of the number of notary offices. While numerous clauses is closed, while numerous regulators is a dynamic value. That's the choice of the government that was mentioned by Mr. Yakovlev. He did not say that to be liked by notary officers. He said that because he has to take into account societal interests. We carry out the functions delegated to us by the government, and the government has to decide whether they want to liberalize our profession or not, as they make a decision similar to what they did in the Ukraine, where you can have as many notary offices as you will. Or the government will be better off limiting the number of notary offices in the nation. If we opt for liberalization, then why don't we have as many judges as possible? We are judges anyway, we are referees. And in that sense, politicians have to make a choice. I am thinking about the discussions we had with our Chinese friends about 15 years ago. The same issues were raised. The Minister of Justice, Mr. Jan, said quite wisely that they wanted to control the number of notary offices because they were reluctant to give the government stamp to the people whose ethical standards and professional level they were not sure about. That's the reason why this government stamp and government authority means a lot of responsibilities in addition to freedom. So we have advantages, but they must be measured against our duties and responsibilities. And if we don't do a good job carrying out the responsibilities, we'll be destined to death, professional death. It will be difficult for us to maintain our status. So let us think about ethics. Let us be servants of the government, servants of the people. And the second question, Professor, surprised me somehow, but I heard the same question yesterday or 2 days ago, because that's the choice which is was made by the Russian Civil Code. Real estate deeds by individuals and real estate deeds by corporations, which will be liberalized. If I'm allowed to express my view, what we need is this, a notarial act makes the deed official, transparent. It certifies and verifies the authenticity and appropriateness of the deed. And the companies or individuals which were in the habit of selling land plots, those were companies rather than individuals, because they are more mobile. Individuals tend to live on the same plot of land for a longer period of time. What problems can be related to that or associated with that? Money laundering, for example. And if the companies choose to circumvent the notary office's services, that creates lack of transparency for the deeds and for the transactions, and that is always very helpful for money laundering. That's the reason why an increasing number of countries have now the system of liability, foreigners' liability for real estate deeds. In an increasing number of countries, the government wants even the company documents to be notarized. And even the letters of incorporation, the documents used to found a company, or marriage documents, they all are notarized on a regular basis. And it is quite logically that if you have a restructuring in a company or a merger or acquisition, you want to notarize that as well. And the last thing I would like to mention has to do with certifying or verifying the signatures. You raised that. I quite agree with Russian notary offices who refuse to verify signatures. When we talk about certification, the whole idea of it is to make sure that you know what identity you're talking about, to make sure that the person is capable and competent, and that he acts out of her free will. It's not the same thing as verify signature. This Vietnamese case comes to mind when the notary office received certain authority, and the lawmakers wanted the signatures to be verified by local councils. That was the name for an administrative body in Vietnam. We need everyone to take their proper positions. We want everyone to be responsible for what they are supposed to do, and the success of Notariat is about meeting the fundamental need of our respective societies. That's the reason and cause of modernization of the notarial profession here. Thank you very much, Ms. Chairperson. Thank you. This extremely interesting event is coming to its close, and I'd like to give the floor to Ms. Chairperson to sum up the results. I realize that Madame President Roche has to run to the airport. I don't want to make my final remarks too long, so at the outset I'd like to thank her for being an excellent moderator, for keeping all her promises that she made concerning the timelines, and thank her for being so wonderfully understandable, so well organized in how she reviewed and analyzed and critiqued everyone's presentation. Thank you so very much. Because the floor ended up back with me, I really don't like it that people in the audience have been so silent. Oh yeah, I realize you all must be very tired, and it is really late in the day. Well, if you insist you want to have a break, it's your own fault. You have no one else to blame for that. Let me tell you that at 1:30 there'll be lunch served in the same place as yesterday. I'm not sure whether it's a seated lunch or a buffet. And after the lunch, I think we all are entitled to a break and a walk in St. Petersburg. You all know what the afternoon agenda is. As for tomorrow, I would like to ask you, those of you who are staying here, to come to the civil code discussion. Because it will help you to develop your own perception of the situation, and also you'll have a chance to participate in the dialogue. Okay, thank you all so much for your work. My special thanks go to my foreign colleagues for their interesting and educational presentations, which are extremely beneficial to us. My special thanks go to Monsieur Decor.
Приятного аппетита вам всем!